The Albanese government has approved legislation to enable the expulsion of non-citizens from Australia, which includes paying other nations to receive those freed from immigration detention, resulting in the termination of their bridging visas and potential re-detention. Welcome to the channel. Please, if you're new here, like and subscribe so you don't miss new updates and hot gists. Tony Burke, the Home Affairs Minister, introduced the measure to strengthen the government's power to remove people who have had their visas cancelled to third countries on Thursday. During question time, Burke stated that the government has implemented regulations to reapply ankle bans and curfews to persons released by the High Court, as well as legislation required to have all the full powers we want to be able to have in terms of removals. This government's first priority is community safety. The first priority is not ankle bracelets or detention for these people. Our first priority is, we don't want them in Australia at all. According to its explanatory memorandum, the measure authorizes the government to pay a third nation to take illegal non-citizens from Australia, such as the 224 persons freed following the High Court's November 2023 NZYQ judgment that indefinite immigration detention is unlawful. If a third country agrees to accept an illegal non-citizen, the minister is required to notify the holder of a bridging visa or BVR of their permission to go to a foreign country, ceasing event that results in the termination of their BVR. If a person becomes an unlawful non-citizen due to the cessation of a bridging visa, or the person may be taken into immigration detention under Section 189 of the Migration Act, and may be liable to be removed under Section 198 of the Act, noted the memorandum. In certain circumstances, if a foreign country that is a party to a third country reception arrangement has granted permission for the person to enter and remain in that country, there would then be a real prospect that the person may be removed to that country under Section 198 in the reasonably foreseeable future. The government secretly claims that the measure will assist solve the issue of non-citizens rejecting to be relocated in New Zealand, which has committed to accept up to 450 migrants from Australia. However, by establishing a new mechanism for removal for non-citizens on BVRs, the bill may allow the redetention of the more than 200 people released as a result of the NZYQ High Court ruling. Because the High Court ruled in ASF 17 that refusing to assist with removal makes detention permissible, those who refuse to travel to a third country may be jailed indefinitely again. Burke informed the House of Representatives that the additional powers would be used in accordance with our international non-refoulement obligations. The measure also introduces immunity protections, stating that officers are not liable under Australian law in respect of civil claims if they act in good faith. According to David Shoebridge, the Greens immigration spokesperson, the bill gives the government fresh powers to pay countries like Nauru and PNG to take people against their will if the minister orders them to be removed from Australia. If this law passes, then people who have come to Australia having fled persecution from Iran, Afghanistan or Russia will face either indefinite detention or removal to countries that have been bribed to take them, he told reporters. We urge Labour to drop this measure, stop attempting to out-Dutton Peter Dutton on migration, and respect the High Court's verdict. The government also intends to reinstate ankle bracelets and curfews for some people freed from immigration detention by legislating that the restrictions are no longer the default, reversing revisions proposed by the coalition and approved by Labour. Burke issued new regulations on Thursday to reclaim the authority to apply the conditions, only if the minister is satisfied that the bridging visa holder poses a substantial risk of seriously harming any part of the Australian community by committing a serious offence. This follows Wednesday's top court finding that the present regulations violated the division of powers and amounted to punishment. The YBFZ ruling will temporarily remove 150 non-citizens from electronic monitoring and eliminate 130 curfews. Previously, Burke told the House of Representatives that ankle bracelets and curfews are designed to protect the community, not as a punitive measure. Burke took aim at the coalition, saying that the clause that ankle bans and curfews were the default was actually not in the original bill offered by Labour but became part of amendments agreed to between the government and opposition. In May, lawyers for the plaintiff in the YBFZ High Court case noted the fact that onerous visa criteria were the default as part of their successful appeal. The new legislation aims to protect the Australian population from serious injury, as stated in its explanatory memorandum. The new test requires consideration of the risk of particular criminal conduct occurring and the nature, degree, and extent of harm the bridging visa or holder may pose to any part of the Australian community. according to the statement. For visa conditions, financial and debt reporting, ankle bracelets, and curfews can now only be imposed if the minister is satisfied on the balance of probabilities that the BVR holder poses a substantial risk of seriously harming any part of the Australian community by committing a serious offence. Significant offences include those punishable by at least 5 years in jail and resulting in death, significant personal injury, sexual assault, child abuse material, child sexual offences, family or domestic violence, inciting violence, people smuggling, or human trafficking. The minister must be additionally satisfied that the imposition of the conditions is, on the balance of probabilities, reasonably necessary, and reasonably appropriate and adapted for the purpose of protecting any part of the Australian community by addressing that substantial risk. Burke introduced the bill, saying it must go through within a reasonable time, but does not have to be rushed through this week.